So this video is all about what information do you need to gather when you start the process of creating an estate planning legal program, with an emphasis on making sure that your family avoids the probate or avoids that succession, that court-supervised judicial proceeding, which is necessary if you have things in your name when you pass away. So we get that question a lot. Paul, what do we need to get started? And it's probably less than you think. So there's family information and there's asset information that you can gather. The family information is really pretty simple. It's things like what are the names of the people who are going to be participants in your estate plan, who is going to inherit, who's going to receive, who's a beneficiary. And that's typically, spouses, children, sometimes it's grandchildren, sometimes it's other people. So most people don't have a problem providing that, information in full. How would you like to see those names listed in the legal documents? Although some, grandparents aren't quite sure what their grandchildren's, actual names are, middle names and that kind of thing, but we get through it. So a lot of people ask, do I need to get all these people's social security numbers? And most of the time the answer is no. Yes, on some, IRA beneficiary designations, you're required to list social security numbers, but that's really a separate component from that, living trust-based estate plan. So really pretty simple there as far as family information goes. On the asset side, yeah, you should have a good working knowledge of what you own, but you don't necessarily need to provide a lot of written, detailed documentation to get started, although it is really helpful and saves everybody a lot of time and effort. If you do own real estate, if you can provide those legal descriptions of your real estate on the front end. So if you own property in Louisiana, you may have acquired it through an act of sale that lists the full legal description. Sometimes people ask, is the property tax notice enough? It's a good start, but better if you provide that act of sale with the full legal description, or that judgment of possession if you inherited it through a probate, from family members. And so that saves a lot of effort from going through, courthouse channels to get that information. And if you own property out of state, again, providing that information can be real helpful. So we can do what we need to do to make sure all that property in and out of state gets in trust, to avoid the multiple probates in multiple states, which occurs when you own property in more than one state in your name. All of the investment information, yes, it's nice to have a good working knowledge up front, but the real estate stuff is really what we need up front, because at the time that you sign your estate planning legal documents, including your trust, you'll likely also sign those transfers of the property into the trust, so we can have all that prepared at once. Now, your investments, perhaps your brokerage accounts, those can't be transferred to your trust until after you sign your trust, and then you go back to those financial institutions and simply retitle those accounts into the name of your trust. So we don't need all that on the front end. So everybody's circumstance is different, and what I didn't address in this video is all of the substantive decisions that you're going to make as part of putting a program in place. But that really just can't be provided. That has to be asked and answered and listened to, and your estate planning attorney will walk you through all the relevant decisions and find out really what it is that you want to accomplish. So from a substantive standpoint, that's all going to be handled in conversations. So that should give you a good idea of what you need to provide. It's easier than you think, and so go take care of your business.